Thank you very much. So I think I'm going to build a lot on what you said before, and probably trying to push also in a different direction, but that largely overlaps with what you said. So basically, my talk will be about the evolution of what my colleague Gregory Lekovich, who will speak a bit later, and myself have called smart law. Oh, I have to change my slide before that. Okay. Which basically stands for scientific, mathematical, algorithmic, risk, and technology-driven law. And the idea of smart law is part of a larger project we are developing with École Polytechnique, HEC Paris, the University of Cambridge, and the University of Brussels. And in this talk, I would like in particular to put down some ideas for discussion about how smart law collapses certain analytical distinctions, which doesn't go that far from what you said before, but in my specific case will be between facts and rules, which constitute actually the grammar that legal professionals, judges, lawyers, regulators use to enforce, apply the law itself. So this collapse between rules and facts is actually further exacerbated when devices use learning algorithms and data analysis and implement automated execution. The centrality of rules, but the former speaker said that very well, has been widely discussed by analytical jurisprudence. And if we go back to Hart, one of his main objectives in the agenda he had in the concept of law. Now, in practice, such stress testing of algorithms can only be performed by other algorithms, which means that MiFID implements, MiFID and all the delegated regulations set up the requirement of algorithmic stress testing of high-frequency trading algorithms. And as a consequence, firms like AlgoGuard have developed Guardian algorithms, right, to perform this test and certify in the end that algorithms in MiFID II are EU compliant, EU law compliant, based on a pass-fail basis. Now, this brings me to the conclusion of my talk, which is how do we uphold the rule of law in this entire process? To what extent are these devices actually compliant with principles such as predictability, generality of the law, or the principle of non-discrimination? And moreover, how can we actually control for these violations? So if you think about Connect, there might be, the taxpayer finds actually himself in a totally extreme situation. First, it is unclear what concrete rule he has breached because it is based on his lifestyle. Second, we may inquiry whether there are any particularities in the profiling process that makes him more likely to be flagged, or in any case, leads to consider his actions or behavior to express a higher risk or probability of fraud. So if there is this particularity, this means that there are discriminatory elements in the profiling process, or in any case, some lack of generality in the rule applied by the system to the behavior of the taxpayer. I think this is interesting. Timothy Endicott recalls that generality is a principle of the rule of law. I'm not going to go through the citation, but he says, well, we do need generality of rules for this. So, of course, the other issue here is the burden of proof, which is unfairly put on the side of the taxpayer, knowing that his capacity to provide factual evidence is way lower than that of the tax authority. So they are not at arm's length, right? And corrective measures may be required. Now, what solutions can be implemented? And this is my conclusion. I believe that there is a paradox today. There is a paradox today with the evolution of norms. I don't know if microdirectives is probably one of the directions. So on the one hand, there is a first dynamic in the production of new type of norms, framing the behavior of individuals and organizations that is independent from the will of the sovereign for many different reasons. In this particular case, because technological developments allow for the production of reflexive rules, fact rule-based, which is what I provided with examples with. On the other hand, there is a feeling that these norms need to be subject to some legal or even judicial accountability. So can the European Court of Justice does the European Court of Justice has any interest in verifying the conformity of an algorithm to European Union law? Would be an open question, right? If this is effectively regulating some specific behavior. I would believe that the most realistic solution at this stage is to design mechanisms to certify algorithms to be rule of law compliant. This is our bet with the Smart Law project I just mentioned before, but we know many challenges lay ahead. We already filed a request for the dataset of Connect and for the source code. And we also know, and that's my conclusion, that this certification, and I will not develop, this certification is only the very beginning, and it is not viable but necessary, and insufficient but necessary. Thank you.